We are still under topic 4, settlement dispute techniques. In the end of the last video, we had concluded talking about diplomacy, international court of justice, and international arbitration. We are now going to get into international tribunals, and the only difference I can really see between international arbitration and international tribunals is that international arbitration occurs under the umbrella of a larger organization like the WTO or under the World Bank in the settlement of investment disputes. Whereas international tribunals occurs under a treaty like formerly NAFTA, now the Canada-US-Mexico agreement. So we're going to look at that particularly agreement, and there's right now 3 settlement techniques in there. There used to be 4. There used to be one that was very much like the Center for the Settlement of International Investment Disputes. That was Section 11. It has been dispensed with for some reason, and I don't know why, but it's irrelevant. The second is Chapter 20, which just is a government thing. Okay, if there's a dispute between one of the governments or 2 of the governments or perhaps all 3, they can have a panel formed under Chapter 20, which will then settle the interpretation problem under the agreement. The chapter that we're most concerned with, because it relates to business per se, is Chapter 19, BiNational Dispute Settlement Panels, or Tribunals. And they settle anti-dumping and countervailing duty disputes. There is another mechanism for settling disputes. So far, the investment one and the interpretation one and the dumping one were all concerning governments. And before the change to the NAFTA agreement, the people involved in negotiating the agreement were updating it and making minor amendments. And they decided, maybe because it was working so well between the 3 countries for government disputes, that maybe they could expand the applicability of NAFTA and actually have a provision in there that would help solve private disputes. Okay, so if I sold goods in Washington State, and the U.S. government said, hey, wait, you're selling it at below market value, you're dumping, they could put duties, countervailing, anti-dumping or countervailing duties on me. And that would level the playing field as far as the price goes and protect Washington State producers. But that was government, okay? And if they did that, then the Canadian government would step in and they would see whether or not they thought that was valid. And if they didn't think it was valid, then they would start a panel under Chapter 19. But that doesn't help me as a producer of a product if I sold, for example, milk to Mexico and the Mexican business did not pay me. I mean, that doesn't even fit under NAFTA or the USMCA. Why? Because it's a private dispute where the others are government disputes, right? So what they decided was maybe they should put in a provision that would allow for me, the seller of milk to that company in Mexico, to actually have that dispute go to a tribunal for arbitration rather than having to go through the courts, which is very costly, time-consuming, etc. Well, they put in Article 2022 just for that purpose. I mention it in passing, pardon me, because it's never been used. I had the president of the BC International Commercial Arbitration Center in Vancouver come out to talk to us, and I asked him if there had been any disputes settled under what's called CAMCA, the Center of the Americas for Mediation and Arbitration Disputes. And he said, well, I don't know. It's nothing to do with us. And I said, no. Vancouver has been designated as the center for that. And he said, no, it hasn't. And I didn't call him on it in front of my class, but the website for CAMCA actually says that for Mexico, it's Mexico City. For United States, it's New York City, and for Canada, it's Vancouver under the BC International Commercial Arbitration Center. So he didn't even know. So there have been no disputes settled under it, so it's kind of irrelevant anyway. But it's available. Anyway, back to the BiNational Panel for dispute settlement. If one of those is formed, then under NAFTA, what used to happen is Canada would appoint 2 members to the panel, and the United States would appoint 2 members, and then those 4 would appoint another one. The very first dispute under NAFTA, under the Free Trade Act, was a BC business selling raspberries in Washington State, and the United States said, "Hey, wait, no, they're dumping," and they assessed $88,000 in duty on that small raspberry producer. Canada stepped in. It went to a binational panel. And it was 2 Canadians, 2 Americans, and then they chose another American. And everybody went, oh, well, we know the outcome of that, don't we? In actual fact, they took their job very seriously. They looked at it and they said, no, that is not dumping. And they said it's so blatantly wrong, they sent it back to the government office in the United States and saying, take a look at that. You probably want to stop that because it doesn't make any sense. And they brought it forward anyway. So it went to the panel, and the panel said, not dumping, period. And the United States said, hey, let's go to the extraordinary challenge mechanism because, we think you're wrong. Well, it went to this extraordinary panel, and the extraordinary panel said, well, no. This is not an appeal where you say, I got the wrong decision here, so I want the right decision here. You only get to the extraordinary panel challenge mechanism if there has been an indication of bias. How do you figure there's bias with 2 Canadians, 3 Americans, right? So it was dismissed. So we won the very first case. Then we won a series of cases. And then all of a sudden the United States started winning them. Just probably based on the problem at hand, right? But the United States was winning more than Canada when Trump said, hey, that isn't working, that isn't fair, and he wanted it dumped. Well, I don't know whether he wanted it dumped or not, or whether this was a negotiation technique saying, we'll leave it in if you give up other things. Anyway, the dispute settlement technique for settling disputes with anti-dumping and countervailing duties is still there. And now, of course, 2 Americans are appointed, 2 Canadians are appointed, and then the other person would be from Mexico, or 2 Canadians, 2 Mexicans, and the 5th person would be from the United States, depending upon how the disputes fall. Anyway, that's the way those disputes are settled. So the Chapter 11 investor dispute is now dispensed with, which leaves us with Article 2022, and it's never been used yet either, because disputes either go to court or because the parties have not put in an arbitration clause, or they're handled under the International Commercial Arbitration Act, which does exactly the same thing, but we'll get to that later. All right, so now we are going to look at the next way that disputes are settled, and that's with reference of the matter to the municipal or domestic courts. So if I was a business person in BC and I sold milk to a business in Mexico and they did not pay, what do? All right, well, I don't know about Article 2022, and we haven't written it into the contract, so I don't have access to that. So my only option is to go to court and sue. Do I go to court in BC and sue and get a judgment here, and then have to take the judgment down to Mexico and go into court again down there and try to register my judgment so I can execute against it? Or do I go to court in Mexico, which sounds like the logical course, Except, wait a minute, BC is common law, and I'm pretty sure it's a breach of contract under the common law, but I don't know about civil law. I don't know what's in the Civil Code of Mexico. So suddenly I'm going down there, I'm hiring lawyers, I'm in a foreign court, and it's time consuming, it's very expensive to go down and back and forth, and particularly in COVID-19, how do we do it? Well, we do it by, video conference or whatever, if they're set up for it. It's a real problem. But the domestic courts are called upon to settle international disputes, both crimes and torts or breach of contracts, okay? And it occurs when there is a forum state, one of the parties is in a forum state, and the accused is not a national of the forum state, or the contracting parties are in different states. All right, a short break there. Despite the growing popularity of private arbitration for resolving disputes, like the example I gave, the municipal courts are still more often than not called upon to resolve these kinds of disputes, and so we are going to spend a lot of time on this one, and that should be a hint that this one will be stressed on the exam. When a court has a case come before it, it will either be a public law case or it will be a private law case. A public law case will be a criminal trial of some nature. A private law dispute will either be a tort or a contractual dispute. On slide 58, the first three elements are what we will have to work through in both those examples. The court has to decide what the forum is, what the jurisdiction is, and what the law is. Okay. Now, the forum is fairly automatic usually, because what it is the territory or state where the court is located and the matter is commenced. Okay. Jurisdiction, however, turns out to be a problem. Does that forum court have the jurisdiction, i.e. the power, to hear the dispute? Okay, and once the court gets over that hurdle and says, okay, the forum is the BC Supreme Court and we have jurisdiction over the parties, then they have to turn and decide what law to apply. And right away you go what's the problem? You're in BC, it's the BC law. Not necessarily. When one party is in BC and the other party is in Mexico, or one party's in BC and the other party's in Quebec. Is it Quebec law and BC, or BC law? Is it Mexican law, civil code, or is it BC common law? So you have this problem that there is a potential of what they call conflicts of law situation. And we'll get into that a little bit later on. And then the last bullet in the start of this slide is immunity. Does one of the parties have immunity to prosecution under that court? And that is very narrow application, and we'll just touch on that later on as well. Criminal matters are relatively straightforward in the sense that the forum and law is relatively straightforward. So it's only a matter of jurisdiction, and by that I mean how do they take jurisdiction over the person? And we saw that in the SS Lotus case, where Turkey wanted to take jurisdiction over the first officer of the French ship, and France was saying, no, we have jurisdiction. We've got jurisdiction because he's a national. And Turkey's saying, no, we have jurisdiction because it happened in our territory. And so right away, bingo, those are two of the principles we're going to look at. There are actually 5 principles, and anybody smell a potential Part B exam question? There's 5, but really Canada only applies 2, and the United States and nations like that apply 4 of them, and then the 5th one is has been seldom relied on as of late. It used to be used in older times. Okay, so the 5 are territorial principle, the nationality principle, the protective principle, the universality principle, and the passive personality principle. So a crime has been committed. And the BC Criminal Court wants to take jurisdiction. So obviously the forum would be BC Criminal Court, and the law to be applied would automatically be Canadian Criminal Code. Okay, so the only question then is jurisdiction, and they would look to see, did the crime occur in Canada? If so, Canada could take jurisdiction on the basis of territoriality. So a foreign national in Canada commits a crime. How do we try a foreign national? We can try them on the basis of the territoriality principle. Also, we can, if it's a Canadian person, then obviously we can take jurisdiction over them based on the nationality principle. He's a Canadian. So if a Canadian commits a crime abroad, we can actually have that person extradited back to Canada on the basis of the nationality principle, saying we will try them here. Okay. The third one is the protective principle, where a criminal, an international criminal, is passing through Canada. Can we apprehend that person? I'm sorry, there's a knock at the door, so hold on. Sorry for that interruption. Getting a lot of interruptions today. Anyway, hopefully there won't be very many more. One of the problems of COVID-19 working out of your house is that your house is not as private as an office where you can close your door and hide. Anyway, we're talking about the protective principle. So there's an international criminal, and word goes out from Interpol or whatever that to look out for this person. They're passing through Canada, and we grab them. Well, we grab them. Is there a way that we can put them on trial? Generally, Canada would be very, very reluctant to do that. What Canada would probably do is, if there's a country that wanted to prosecute that person on the basis of a territoriality principle or nationality principle, we would allow that person to be extradited back to that country. But let's say it's an international criminal and we want to deal with him or her. What we could do is we could use the protective principle. They didn't commit a crime in Canada, and they're not a national of Canada, but we want to protect the world from this criminal. So we can use the protective principle. The next one is the universality principle, and this is what the United States uses to go after terrorists. If they apprehend terrorists, can they put them on trial in the United States? Yes, they can, on the basis of the universality principle. They're not a criminal, so it's not protective, but the United States is protecting the whole world against this person. The protective principle is you grab the person that's a criminal to protect Canada. Okay, but the universality says you grab this person, you're protecting the whole world from the terrorists, and so you can put them on trial. There was some contemplation about doing that with Saddam Hussein when they grabbed him, but they decided to let the Iraqi government put him on trial. Okay, and the last one is the one that's not used very often, and that is if we can get our hands on the perpetrator anywhere in the world, any nationality, as long as the victim was a Canadian national. So that's the passive personality principle. Not used very often because you'd have to have bounty hunters go out and grab somebody and bring them back and then put them on trial based on the victim. Okay, so the proper law, once you have jurisdiction, is the domestic or municipal criminal law, and the forum is obviously the BC Provincial Criminal Court or the BC Supreme Court. All right, so that's criminal cases. Relatively straightforward. We get into commercial cases or tortious cases, and suddenly the water is really muddied. And when I was practicing law, I really enjoyed doing this because it required a lot of consideration of case law on an international basis, and it was quite a bit of fun. So we're looking at three things: the forum, jurisdiction, and law. And we're going to look at civil cases now as opposed to criminal cases. How do you take jurisdiction? Okay, because the forum state is generally where the action commences. All right. So then the next question is, It started in BC, but do we have jurisdiction? And the jurisdiction is decided on the basis of the real and substantial connection doctrine. The real and substantial connection doctrine. So they look for a nexus, some connection. All right? Now, there's two types of jurisdiction. So there's jurisdiction, the real and substantial connection, and then there are two types. In personam jurisdiction, in rem jurisdiction. In personam means jurisdiction over a person. In rem means jurisdiction over the subject matter. Okay. Okay, let's look at in personam jurisdiction. In personam jurisdiction, the court has the power over an individual person or juridical person. What's a juridical person? A juridical person is a corporation. Okay. And they have to be physically present in the jurisdiction. So individuals subject to in personam jurisdiction, there are four of them. Nationals of the forum state, obviously. Natural persons physically present here. Natural persons domiciled here. Okay, so one is somebody who lives here and is a national of Canada. The second one is someone who is physically present here, either for the purposes of doing the trial or probably they were here for the purposes of doing business. And natural persons domiciled here, so this is a foreigner living in Canada. And then the last one is natural persons who consent to the jurisdiction. Okay, juridical person at the bottom of that slide, number 60, is just indicates that it's a legal entity created under national or international law. Okay, in rem jurisdiction is the power of the court to determine ownership rights of persons' property located in the forum state. Okay, now there was an interesting case involving leases in, I think it was Brazil, mineral leases in Brazil. And the BC court took jurisdiction on the basis of in rem jurisdiction, and they no, the land is in Brazil, but the lease was a document executed in Canada, and it was the a document, a contract is actual property. Okay. It's intangible personal property, so they took jurisdiction over the intangible personal property, which just happened to deal with leases in Brazil. So kind of a creative way of doing it. All right, so we're talking about property. So the first thing we have to do is really figure out what the courts mean by property itself. And property breaks down into two categories, real property and personal property. Real property is land, buildings, and things permanently affixed there too. So trees are permanently affixed. No, they can be cut down and taken away. Yeah, but the courts take the attitude that a tree is there, it's cut down, there's a stump, and there's slash everywhere. Okay, and then the wood's taken away. And so because substantial damage is done, it was permanently affixed to the property. So minerals in the ground, permanently affixed there too. So a building, well, unless the building can be easily moved, it would be considered to be part of the land. Inside the building, though, things get a little confusing because a light fixture, like the one above me there, is obviously can be taken off. Okay, so that would be personal property because you take with it. But the wiring, which goes through, okay, if you wanted to take that, you'd do substantial damage to the building, ergo it would be permanently affixed there too. Things attached with bolts and screws are considered to be personal property because bolts and screws can be taken out. Things hammered in with nails are considered to be part of the land because that's intended to be permanent. Okay, so that's real property. Personal property, again, breaks down into two categories. One is tangible personal property, like the mouse that I use, my computer, the table, the chair I'm sitting on, the light fixture. What else is behind me here? The lamp. Okay, yeah, that's personal property. It's just plugged in, so no problem. You can take it with you. Then there's other things like cars and sailboats and computers and desks and whatnot, all personal property. They're tangible because of they're valuable for what they are. All right. Now, my glass, this is soda water. The glass is personal property. The soda water is actually personal property because it's valuable for what it is. It's a drink which lubricates my throat so that I don't go too often because of my allergies. Okay, intangible personal property. Intangible personal property is anything that has value for what it represents. We used to call it shows in possession and shows in action, the French term. Shows in possession, something that you can possess. So I can possess my mouse. I can possess my pen. And everything else was shows in action, something that I could sue for. Okay, I can sue on a contract. So it's intangible property. But then they thought, no. The better way to look at it is just it's valuable for what it represents. Now, I don't think I have any money on me. Oh, yes, I do. It's an international business class, so what's more appropriate than having a 200 peso note? Okay, so this represents my ability to buy a cerveza in Mexico. So is it valuable because it's a banknote? No, it's valuable for what it represents, okay? The paper is not really valuable at all, okay? But it represents wealth. Trademarks, copyrights, industrial designs. This glass is a Disneyland glass, and I'm just going to shift over my photo booth and put it up there as close as possible. Well, you can't really see it, but there's an R in a circle there. What's that? Well, that's a registered trademark, okay? So a trademark, what is that? Is that personal property? No, it is a... well, yeah, it's personal property, but is it intangible or tangible? Well, it's intangible because I can't hold the trademark, but the trademark represents Disney Corporation's goodwill. The copyright in the textbook that we use for the course. Copyright is obviously intangible, but it represents the ability of the author or whoever he assigns it to make money off the textbook. So trademarks, patents, industrial designs, copyright, proprietary information is intangible property. It has wealth, okay? It represents wealth. A contract, if I had a contract and I was going to be paid $180,000, I could take that contract to the bank and I could assign it to the bank in return for financing now. So because I can assign it, it's intangible personal property. A check represents a piece of paper that's worth next to nothing, but it represents my ability to take that check to the bank and withdraw cash for it. There are some things that get a little more confusing. Gold earrings, for example, in your ears, adorn you and make you more attractive. All right. So even though gold has might represent wealth, in that particular circumstance, gold earrings would be tangible property. But a gold bar, well, you don't wear a gold bar on your ear. So obviously a gold bar represents your ability to cash it in and use it as currency, ergo it's intangible personal property. Painting, my mother-in-law, before she passed away, was an artist of some ability. We had paintings all over our house. The question then is it intangible because it represents wealth? We'll be able to take them and sell them? No, she was famous, but not that famous, or well known, but not that famous. So that would be tangible. Okay, why? Because it represents. It's valuable for what it is. Okay, whereas the Mona Lisa, although it can be considered tangible property, is worth what, $25 million or something. So obviously the Mona Lisa represents wealth. Okay, what else? My ability to sue for a personal injury is I have a cause of action. That would be an intangible property because it represents wealth. And that's about it. I can't think of anything else. Anyway, now that we know what property is, we know what in rem jurisdiction covers. On slide 62, it shows tangible property, a container falling off a ship into the water. It's valuable for what it is, or what it was as it sinks to the bottom. Intangible property is the trademark on the container. And the trademark at the bottom is for Maersk, which is an international container shipping company. I put that on there because I was on a cruise not too long ago, and I met a representative from Maersk, and he was going to Papua New Guinea, where he was going to open up a brand new office for them. We got to know him and his kids quite well on the cruise. All right, so the only sort of problem that can crop up in this concept of taking jurisdiction is forum non-convenens. It's another doctrine which says that a municipal court may refuse to take jurisdiction or hear a dispute when it could be better or more conveniently settled in another court. Okay, so every once in a while they look at it and they go, well, one of the parties plus all the witnesses are in, Bajinajistan. The subject matter is in Bajinajistan. Why are we here? Okay. And so even though they could take jurisdiction on some basis, they decide to say forum non-conveniens and make the matter heard in a foreign court. Okay, proper law. When we have one party in one jurisdiction and one party in another jurisdiction, we have a potential conflict of law situation. Almost always a potential conflict of law situation, because laws are never identical. Well, I shouldn't say never, but most of the time not. So if both the forum state and another state have some legitimate interest, then the forum state must choose what law to apply. And this is really something that applies to both substantive law and procedural law. And there's an article called Gambling on it. Okay, I am going to post it to eLearn, and I will talk about it later. Hopefully you'll have a chance to read it in the meantime. But it was a situation where the outcome of substantive law or procedural law meant that a person may or may not be liable. There are three ways of choosing the law to apply, and vesting rights doctrine applies to tortious matters. The most significant relationship doctrine applies to contractual or commercial disputes, and the government interest doctrine applies in situations where very rarely a government has some tremendous interest in the outcome of your particular commercial dispute. We're not going to worry about the government interest doctrine other than perhaps, I apologize for my allergies, other than perhaps passing reference on the terms in the party of the exam. Obvious tort is considerable because a business in one country can pollute through transmission of air particles or something into another country, and a tortious action can be brought, or a product made by a company in one country can be sold in another country and cause an injury, or a person can be traveling and staying in a hotel in the United Kingdom and slip in the bathtub and injure themselves, and so they're a national of Canada, but the tort occurs in the United Kingdom. So the vesting rights doctrine is something that we have to take into consideration, and the court applies the law of the state where the rights of the parties legally became effective. So you slip and fall in the bathtub in the United Kingdom and you return on crutches to Canada and you want to start an action here, the answer is no, you cannot. Because the injury occurred in the United Kingdom, and that's where your rights legally became effective. Okay, so a tort or a delect. Okay, tort is the common law term, believe it or not, even though it's a French word, and delect is a civil law term, meaning a wrongful act or injury or damage caused to an individual, but not involving a contractual dispute. Okay. The law of the place where the tortious act was committed is the law that applies. Simple as that. It gets a little more confusing when you get into the most significant relationship doctrine. The most significant relationship doctrine is how you decide what law to apply in a commercial dispute. Okay, and the law of the state that has the closest or most real connection is the nexus, is the most significant relationship doctrine. And the courts look at 5 things. Okay, they could say, oh, one, got them, but they generally look at a number of those items in order to determine whether they feel solidly in control of the law situation. So the first one is the place of contracting. Where did the parties contract? Internationally, that is not always a really good way of doing it, because one party's in one jurisdiction, the other party's in another jurisdiction, and they communicate by email. And then they exchange a letter of intent or whatever, and then the lawyers draft a document. Well, was the place of contracting in BC or the place of contracting in Australia? And, oh, well, obviously, where did they get together and sign? Maybe they didn't get together and sign. Okay, maybe there was a clause in the contract, one of those boilerplate clauses, that allowed for execution in counterparts. So the person in BC has 2 originals of the contract, signs both, and the person in Australia has 2 originals and signs both. Then the BC business person sends one of the originals to the person in Australia, and the Australian business person sends one to the business person in BC. Now I've got in BC 2 copies of the agreement, one signed by me, one signed by the Australian person, and as long as there is an execution in counterparts clause in there, those 2 make one contract. So now I have an executed copy of the contract. The Australian business person, exactly the same thing. So where was the place of contracting? Okay, place of negotiation. Did the Australian business person come to BC and did they negotiate it here? Well, that means BC law should apply. But it might be that he came here and negotiated some, and then I went there and negotiated some, and then the rest was done by internet. So the place of negotiation doesn't really help them either. Place of performance. Oh, well, good. I'm going to send goods to Australia, so obviously performance as far as the Australian person is concerned is when the goods are delivered. So, Australian law applies. No, performance as far as I'm concerned, the performance that I really want is when you pay me. So the place of performance might not be applicable either. But if it's a contract for independent contractor arrangement where the Australian business person hires a BC business person to enter him into agreements and buy and sell stuff here, then obviously it's being performed in BC. Okay. Location of the subject matter. Sometimes that's helpful because in the Brazil-Canada or BC dispute, where we had the lease on mineral rights. Well, the mineral rights were in Brazil, and the lease is here. So as long as you say the lease is intangible personal property, and it's here, then we can take jurisdiction, because that's really important. Okay, the fact that it's a lease is important, where the location of the minerals is not important. All right, so you might be able to do it on that way. Then the nationality, domicile, residence, or place of the incorporation of the parties is also looked at. So you look at all these things. And there is a case that we are going to take, and I think it should be, dear, I don't have it in here, but I'm going to back up. We have, pardon me, right at the top of slide 67, case study, Sharn Importing Ltd. Versus Babchuck. I want you to read that. Okay, now read it and read it and read it and read it. And then in the next video, I'm going to discuss it because it has so many facets that are applicable to the course that it's particularly important. So I'm going to do a separate video on that. So I want you to read that, okay? All right, so now we've seen how the choice of law, the choice of form, and the choice and jurisdiction are all real problems unless the parties think about it ahead of time. And that's why you really want to go to a lawyer, despite the fact that they cost money. Okay, you want to go to the lawyer and have the lawyer draft the contract, because the lawyer is going to think about what happens if. Whereas you're thinking about, hey, I'm going to sell product, I'm going to make a lot of money, and the other party's saying, hey, I'm going to buy product, and I'm going to be able to sell it, and I'm going to make lots of money. And so everybody's really positive at the beginning, and consequently, you don't see the potential problems if a dispute arises. So the lawyer up front will put in a clause as on slide 67 called applicable law. This agreement shall be interpreted in accordance with and governed by the laws of the province of British Columbia. Now you don't have to worry about the real and substantial connection to figure out the law, right? Or the jurisdiction and the law. Then the lawyer will also go on to say in that applicable law clause, instead of ending where there's a period, it will continue to say, to the exclusion of conflicts of law principles, because that will prevent the judge from saying, well, you know, there's a clause in the articles of the Civil Code for Mexico that I think is really applicable to this, and it changes the outcome. Well, the judge cannot apply that. The judge will be bound by the clause that you select. All right, so it's really important to look into the Sharn importing case, and then we'll go over that separately. Okay, that's number 5. That brings us to number 6, private arbitration, the settlement of disputes without recourse to the courts. And there's a couple of articles which I'm going to post to eLearn regarding the advantages and potential problems that might occur in arbitration. For the last 10, 12 years of my legal career, I did not draft a single contract that I did not put in an arbitration clause, because what I wanted to do was to keep my clients out of court. Now, I could have made a lot more money if there was a legal battle, because then I could represent my client and I would have all those billings and I'd go to court and spend a lot of time, and it would be exciting to wear my robes and argue. Well, the problem with that, of course, is that's what I do, that's what I enjoy, but for the client, it's time consuming, incredibly expensive, and very stressful. So you can eliminate part of the stress, have a faster result, and be less expensive if you go to arbitration. Now, I put in an arbitration clause, mediation and arbitration, and fortunately there were only 2 instances where there was a potential dispute, and it went to mediation, and in both cases it was resolved. So I sort of shot myself in the foot in the sense that I get less in the way of legal fees. But in the long term, I think I did much better, because I look at times in my early career when I acted on behalf of somebody, and I don't overbill. As a matter of fact, I'm always I was always having an argument with my office manager because I would pare my bill down and only bill for what I thought was, really necessary. And well, lawyers only do that. But I would even make deductions. Well, it isn't a big client, so I'll cut back my bill. And my business manager said, "Hey, come on, just bill." So I was always having disputes with her. But when I did go to court, or when I was involved in one of these transactions, and there was a dispute, I found that I would often win the law case and lose the client because the client is so fed up by the whole system that they think it's their lawyer's fault. Or even if they don't think their lawyer's fault, they just think, well, maybe another lawyer won't bill as much or whatever. But and so I thought, well, I'd rather keep my clients and not go to court. Be proactive, and do risk management instead of solving disputes, right? And so I would put in mediation and arbitration clauses. Okay, or maybe it just turns out that all those contracts I did were, the business worked out so well that nobody got into disputes anyway. Private arbitration is the settlement of disputes without recourse to the courts. You do not get to arbitration unless you have a clause in the contract, and I will say that again at the end. Arbitration is readily available around the world. Almost all countries now have some sort of an arbitration forum in their jurisdictions. The American Arbitration Association in New York has been around since the turn of the 19th century. The London Court of Arbitration was founded in the late 1800s in the United Kingdom. It's called the London Court of Arbitration because back then it was so brand new they thought that the arbitration would be sort of like a court. Nowadays they don't use the word court with any of the arbitrations. The United Nations Commission on International Trade, UNCITRAL, was a driving force setting up the rules of arbitration. Rather than being a center itself, it actually farmed these rules out to the American Arbitration Association, the London Court of Arbitration. In British Columbia, we are very fortunate. We have the BC International Commercial Arbitration Center. It enforces the International Commercial Arbitration Act, okay? And we are also the Center for Commercial Arbitration and Mediation for the Americas, CAMCA. So arbitration is readily available. Australia has one, the United Emirates has one, everyone has one. Okay, arbitration. I love this cartoon because Jameson, the mediator, uses his last remaining negotiating tool in an effort to break the stalemate. Rock, paper, scissors. Rock, paper, scissors. Cartoons display life. Okay, there are advantages and disadvantages to arbitration. And I think this is probably a pretty good place for me to take a break because I do have to have lunch, so I will come back and pick it up there. Now we're continuing with private arbitration as a method of resolving international commercial disputes, and we're going to look at the advantages and disadvantages. Many of the articles and textbooks that talk about MedArb refer to some of the key advantages and leave it at that. We're going to go into it in a little more depth because I think it's more ethical to look at not only the advantages but list the disadvantages. Over the years, the advantages have been getting longer, and there have been a few additions to the disadvantages, but I think by the time we're done, you'll see that the scale tips well in favor of the advantages. The first one, obviously, and one of the most important, is it is very much faster than going to court. In the province of British Columbia, you get into the Supreme Court of BC in 2 years if you're lucky, usually around 3. That's a long time to wait for justice because justice delayed is justice denied. And what does that mean? Well, witnesses can disappear or move, exhibits can disappear, people's memories fade over time, And so consequently, by the time you get to trial, it's a bit of a what they call a crapshoot. Okay, it's a gamble. So the faster you get into a dispute settlement technique, the better. And arbitration, if you are diligent, or if your solicitor is diligent, you can get in 3 months, 4 maybe. Okay, unless it's a really huge dispute, in which case it automatically is going to take longer. But you get into a hearing faster. It's obviously less costly. Now, I don't put down cheap. Oh, it's cheaper on the exam. Oh, it's cheaper. No, it's cheap. Cheap is a bad term. Cheap is an American sort of, way that they butcher the language. Cheap means poor quality. There is nothing necessarily poor about the quality of an arbitrational award. So consequently, I want you to say less costly. And the other reason I want you to say less costly is it doesn't mean that it's not going to cost very much money. A dispute is going to cost money because you're still going to need a lawyer. You're still going to need filing fees and things like that. Okay, so it just is less costly by a considerable amount. We're going to have a group in the course talk to us about the relative costs of commencing an arbitration. But I remember I had a client come in and he had a $40,000 dispute, and he wanted to sue someone, and I stopped doing litigation, and so we got together with another lawyer and we were talking to him, and that lawyer said, "Oh, thanks, nice talking to you, but I won't take your case." This happened with another lawyer as well, and so finally my client said, "Well, what's going on here?" And basically it was because it's going to cost $35,000 to $40,000 by the time you finish a BC Supreme Court trial. So if somebody's claiming 35 and it's going to cost you 35, you're going to win, yay, and get nothing. Now there will be party and party costs, of course, which will compensate some of your costs. So maybe if you're lucky, you get 50% of your bill paid by the other side. So you recover 35 and let's say $20,000. So you get $55,000. Hey, wow, an award of $55,000. And then you subtract from that the $35,000 that you paid, and you waited 2 or 3 years, had all that stress, wasted all that time, and you get an award of $20,000 when you were owed 35. It doesn't make any sense. So obviously, if you can go to arbitration and it's less expensive, then it will be better for you. All right, the third advantage is confidentiality. Let's say you have a special business process, a pricing system or something like that gives you an advantage over your competitors. So you enter into a contract with another business that's going to sell your products or services or whatever, and then you get into a dispute with them and you want to sue them, and you get into court and you say, they breached my proprietary information regarding pricing, and the judge says, oh, well, what's your proprietary information? And you think, oh, well, okay, this is a court case, it's between me and the defendant, everything that I say in court must be confidential. Well, in fact, no, it's not. Your competitor out there looks and says, oh, look, a lawsuit regarding, my competitor. I wonder what that's about. So he goes down to the courthouse library, walks in, says, here's $5 or $10 probably now. Can I see that file, please? And out comes the file, and he flips it open, and look, there's the special pricing structure. Oh, that's how he's so competitive. That's how he keeps beating me. That's how he gets the jobs and I don't. Okay, well, here's another $5 to the court clerk. Could you photocopy that for me? So everything in a Supreme Court trial is not confidential. And it's very hard to get the judge to agree to confidentiality. And the reason is that our legal system should be transparent. Okay, so let's go to arbitration. Sit down with the arbitrator and say, everything here has to be confidential. Okay, so now I have to keep it confidential and the other party has to keep it confidential. If they breach that confidentiality, then you get to sue him for the breach. Okay, so everything in the file is confidential, and that allows you a big advantage. You can be more open and forthright with the arbitrator. Okay, now you get to choose your arbitrator. I'm going to beat this one to death a little bit because I have an example that I think is really important, and I've touched on it before. There was a person on the Sunshine Coast who was installing windows in her house, and she wanted wood windows, crafted windows. And so she found a workman, a fellow had a business, and she went and looked at some of the windows that this fellow had done, and they were fantastic. And she thought, okay, this is the guy. So she goes to him and she says, I want 3 windows installed. So you take out the old windows, you build the frames, put in inserts, and how much is that going to cost? And he gave her a price, and she said, okay, that's good. So that businessman drafts up his contract, puts in full price, certain amount of money, begins doing the windows, and then says, oh, by the way, you're going to have to pay me more. And the woman said, well, you gave me a firm price, like it's your price. You priced it. And he said, yeah, but it's going to cost more. And she said, well, you can't do that. You can't, halfway through the job, you've ripped out some of my windows, you're building the other things. Now you say, more. And he said, well, okay, well, then I won't finish. And she said, no, you've got to finish. And according to the contract. So he took the windows that he'd built and he left. Okay. And so she, tried to get him to come back and do the job. And he said, I'll come back and do the job. You just pay me double and pay me now. Well, she didn't, and he didn't come back. So she sued him. And it was a small claims court amount, although quite substantial, because small claims court is up to $35,000 now. And so she asked me, because I was a friend, if I would handle the trial for her. And so I gave her a really good price. Anyway, we go into court, and we arrive at the courthouse that morning. And I look at the docket, which is a list of cases, and it says who the judge is. And of course, in the Sunshine Coast, we have one judge. And I went, wait a minute, that's not the judge. A former judge had passed away, and we had a new one appointed. And I said, that's not him. So I went to the registry and I asked what was going on. And the registrar said, well, there is a family law custody matter that is really complex. And so we're bringing from Vancouver a small claims court judge up to the Sunshine Coast to handle that. So that'll be on first, and then your case will follow, and she'll be the judge for that. And I went, oh, great. And my client said, what? And I said, well, now we have a family law judge. Now remember that small claims court, or maybe you don't from 107, but small claims court has, provincial court has small claims, a criminal division, a young offender division, a family division, and a traffic division. So what we had here was a judge that was an expert in family law, and she was going to be sitting in this particular trial. And as matters progressed, it was very obvious that she was very antagonistic towards my client, because here was this poor workman, okay, and here's this, rich woman with her lawyer, and so she was overstepped the bounds of propriety, got involved in the trial, asked the questions, suggested to the defendant what his answers should be. And what was evident from this was that I watched her initially handle the family law dispute, and she was absolutely incredible. She cut to the chase. She knew exactly what should be done. She made an order. Bingo. It was wonderful. And I thought, wow, a really good judge. The problem was that since law school, this person had practiced family law, and then had become a family court judge. And in that whole process, probably never had a contractual dispute. So when it got down to a business matter, she was a fish out of water. Okay, and she now I had the defendant on the stand. I said, "Is this your contract?" "Yes, it is." "And is that the price?" "Yes, it is." "And it says full price?" "Yes." Did you, and now, but now you're asking for more. How could that be if it's your contract and you gave it to the client and the client signed it? How can you then now ask for more? And the judge said, "Oh, well, he must have meant cost plus. It's just a mistake." And, you don't do that. I mean, you have a written contract, you abide by the contract. And she didn't know what to do with the case law. I had case law in support of my position, and she didn't know what to do with it, so just ignored it because it wasn't helpful. And as a consequence, we got a bad decision, and it cost money and delayed matters to appeal. And the woman had to then install the old windows that this guy had taken out and everything. So it was a real fiasco. On appeal, usually, and the family law judge thought she could get away with it, okay, because the amount was not sufficient to start a Supreme Court trial. And so you wouldn't appeal to the Supreme Court because it would be too costly, okay. My client said, "I don't care. Appeal." All right. So we went before a Supreme Court judge. Now, the businessman had already won, so he didn't get a lawyer. Here's a little bit of advice. If you're going to go to the BC Supreme Court, there are pitfalls if you do it yourself, so get a lawyer. Anyway, there I was talking about this judge's errors on the facts, which were numerous. Errors at law by saying this is a cost-plus contract rather than a firm price contract. And then, errors at law in not dealing with the case law. And as I mentioned earlier, the judge is sort of going, "Oh, my God." And he stopped me and said, "Okay, Mr. Holden, what do you want?" And I asked for it to be declared a fundamental breach of the contract. The parties get put back in the position they were in before the contract came into existence. And he said, you may have it, Mr. Holden. Now, the whole point of that story is that when you go into court, you do not get to choose your judge. When you go to arbitration, the parties get to choose their arbitrator. Okay, so it's not like, "Oh, I'm going to arbitration, so look, down the list, there's a friend of mine, I'll choose him." No, you can't do that. They have a list of arbitrators, and it's unlikely that I'm going to know somebody on the list, right? But more to the point is that both of you get to choose an arbitrator. If you can't decide, let the center choose one. The center isn't going to say, "Oh, I like Peter Holden, so I'll choose somebody that's going to..." No, it's not going to happen, right? So you get to choose your arbitrator. You have an insurance problem? Choose someone with expertise in insurance. You have a contracting problem, you choose an arbitrator that has a contracting background. If you have a specific technical legal matter, there are judges on the list that you can choose. Okay, so you get to choose your arbitrator and thereby get a better decision. It's more flexible as to time, and wait, no, we've already discussed how it's faster. Yeah, but it's more flexible as to time as well because, and again, I've got another anecdote. I had a trial, Supreme Court trial, and I went down to the Supreme Court House in Vancouver with my client. We get there at 9 o'clock, which you're required to do. We go to the clerk to find out who our judge is and what room we're in and whether we're prepared to go. And the clerk says, "Oh, I'm sorry, we don't have a judge for you today. The judge is sick." Well, judges get sick, right? So what happens is you go to trial scheduling, another desk in the registry, and you get assigned a judge. So I went there, and there were a whole bunch of lawyers, milling about and talking to the registrar because apparently a number of judges were not available that day. Nothing to do with COVID. This was quite a while ago. But anyway, I was at the back of the line, and finally the registrar said, hold on. Is there anybody here that has a serious matter? And I went, yes, I do. And everybody stopped and looked at me. And I said, I have a matter, I'm representing somebody that wants to be appointed a committee for his mother. They're going to put her in a home, and he wants to have control of that. And she says, okay, you have a courtroom such and such. And all the other lawyers looked at me with like knives in their eyes because they're all trying to do that too. But I was pushy because that was the best thing I could do for my client. Anyway, we get assigned to a courtroom. Great. So we go up at 10 o'clock because that's when court starts. And we go in and we sit down and we wait and we wait and we wait. 10, 15, 10, 20, 10, 25, 10, 35. The judge comes in. Why is she 35 minutes late? Well, because she came in that morning and she was going to be in her office writing out judgments of matters she's already heard. But no. Can you take court today because somebody's sick? And she says, okay. Well, now she doesn't even know what the file's about, so she has to quickly open the file and review what's in the file. So we start at 10:35, and I introduce myself. The other lawyer introduces himself. Then I have a little explanation of what the trial's about. Suddenly it's like 10 to 11 before we really actually start, right? Well, at 12 we take a break for lunch, 2-hour lunch. Why? So the judge can go off and have martinis with friends of hers, or go shopping for new shoes, or a briefcase or something. No, they go back to their office and they sit there and they write out those judgments that she was supposed to be doing in the morning. So at 2 o'clock we come back, and at 4 o'clock we adjourn because that's when court ends for the day. Well, I've had 2 hours and 25 minutes of court time in an 8-hour day. Not so with arbitration. The arbitrator gets paid for the number of arbitrations that they do, right? So the idea is you don't want this to drag on forever, and the arbitrator will call you up and say, okay, let's meet tomorrow. Where are the parties? So one's in Vancouver and the other's in North Vancouver. Okay, I'll find a conference room in a hotel downtown Vancouver, Robson Center or something like that, and we'll see you there at 7:30. And you go there at 7:30 in the morning. You'll have coffee and you'll have muffins there, and you begin working, and you work, and suddenly it's like 10 to 12, and he says, okay, it's almost 12, lunchtime, and you're thinking, okay, well, let's, and he goes, wait, no, just, I've ordered in sandwiches and coffee, and you work through the lunch hour. Okay, and then at 10 to 5, he says, okay, day's almost done, where are we? And I go, oh, well, I'm all finished. And the other lawyer says, well, I've got about another maybe a half hour. Court would say, okay, we'll adjourn and do that tomorrow. The arbitrator will say, okay, let's just push on right through. If it lasts too much longer, we'll order in food. And bingo, you're done in a day. Okay, so more flexible hours. Arbitrators will also view the scene. When I was an article student, I got to follow lawyers around and carry their briefcase and watch them in court, part of the learning process. In this one, it was a motor vehicle accident at a street that wasn't just like this. It had another road coming in, and there were 3 cars involved, and it was, the green car coming down and the red car, the RS coming along here, and they, no, it was the red car was in the intersection, and suddenly the judge says, I can't picture this. We're going to adjourn today, come back tomorrow with a diagram of the intersection. So the next day we're back, and there's this nice big diagram on one of those fold-out sheets, and here's the street and there's the car, and it was still confusing. Arbitration, the arbitrator would say, I can't picture this, let's go. And you get in the car and you drive out to the intersection and you look and see what it's like. I had Patrick Williams, who was the president of the BC International Commercial Arbitration Center, come in and talk to us. And he said he was involved in one where there was scaffolding up the side of a building, and the scaffolding fell down, and way out here in the road, the scaffolding caused an accident. And the judge said, well, how did the scaffolding get from the building out onto the road? And the lawyers go, we don't know. So the arbitrator said, okay, into the car, and they drive out. There's the building, there's the scaffolding, there's the hill, onto the road, accident. Okay, so they will view the scene, which helps substantially with getting a fair result. Preserving ongoing relations. Sorry, I've got another anecdote. I haven't done a lot of court work and arbitration, but I very quickly you can see the advantages. Remember, I'm not sure whether I mentioned it in this class. I had a baker and his wife that had a business together, a corporation. They owned 2 restaurants, and she ran the business, and he was a baker trained internationally in Switzerland, a master baker they call him. They made fantastic Italian breads and pastries, as well as restaurant fare. They started out with one restaurant that was so successful, they built another one 5 times as big. Okay, and they were still so successful that their pastries and baked goods were being sold off premises in other retail operations. And some restaurants had approached them and said, "Can we do your pastries and breads in our restaurant fresh?" And so the master baker figured out how to freeze the dough and package it so that these other restaurants could just heat it up, bingo, and serve it fresh. One day, one of the fellows comes into the restaurant, and he sits down, he orders coffee and some pastry, and has a couple of bites and some coffee, and he orders some more pastry and has a couple of bites and coffee, and then he orders some more pastry and has a couple of bites, and the server says, "I'm sorry, sir, is everything okay?" And he said, "Oh yeah, everything's really, really good, thank you very much." And she said, "But you're not finishing it." And he says, "Well, I know, but can I have this pastry and more coffee, please?" And finally, the server is so worried, she goes and gets Pamela, the owner, and Pamela comes out and says, "Oh, I'm so sorry, sir. What's wrong?" And he says, "Oh, no, absolutely nothing's wrong." He said, your pastries are wonderful. I'd like to sell them in my restaurants, please." And she said, "Oh, well, how many restaurants have you got?" And the answer was, "Only 22. Ching ching, dollar signs in her eyes, right? 22 restaurants. He was out of Seattle, and he had restaurants in Washington State, Oregon, and Northern California. Okay, sort of like those Denny's or Sherry's, or what's the other ones? I can't remember. Anyway, something like that, like a family restaurant. And so they talked for a while, and he said, "Okay, well, we'll need a supplier agreement, so you get your lawyer to draft one up." And that's me, and that's great, because that's exactly what I love to do, drafting contracts of an international nature. And so I began drafting this, and I met with Pamela, and we were going through it, and I said, "Okay, what we should do is we should put in a med-arb clause, all right? We should put in a mediation and arbitration clause. With the Arbitration Center in Vancouver." And she said, "Oh, well, he'll never agree to that." And I went, like, why not? And she said, "Well, he's from Seattle. He won't agree to, arbitration in Canada." And I said, "Well, let's put it in. And if he's upset with it, then we'll negotiate something. Or maybe we'll say, well, we want this, but if we give it up, maybe you'll give up something else, Anyway, so we put it in, and then we meet with him. And I don't know whether he was a lawyer or whether he's just done so many of these that he knew what to do. But anyway, we start going through the agreement with this clause, and he goes, "Yeah, that's fine." This clause, "Yeah, that's fine." This clause, "Yeah, that's fine." I'm starting to worry, okay, because I think, all right, he's agreeing to everything. Am I missing something here? Anyway, we get down to the arbitration clause, and I said, "Okay, disputes shall be settled by mediation, and failing mediation, arbitration in the BC International Commercial Arbitration Center in Vancouver." And he went, "Yeah." And Pamela says, "What? You're kidding. You agree to that?" And I wanted to step on her foot under the table and say, "Quiet, And he looked right at her, and he said, "Lady, have you ever been to court in the United States?" He says, "Trust me, you do not want to go there." He said, "I will happily drive 3 hours north to have the matter settled in arbitration." So it went into the agreement, and that's a long explanation to set up what I'm going to say now. They start the contract. Pamela was responsible for having the frozen dough delivered to Seattle, and then he distributed it to his restaurants from there. And everything's going fine except one shipment, something's wrong with the dough. So he calls up and he says, you'll have to replace that. Pamela says, no, it was fine when we delivered it. It's your fault. You'll have to pay to have it replaced. And he said, your fault. No, your fault, your fault, your fault. And Pamela's a bit of a hothead, so finally she said, oh yeah, well, we'll see you in court. And she slams down the phone, calls me up and says, sue the guy. I said, well, two things here, Pamela. If you sue him, you will lose the business, number one. And number two, we cannot sue them because we put in an arbitration clause. And after she cooled down a bit, I said, Pamela, call him back and tell him that you've taken the file and you've given it to your assistant, who then gave it to his assistant, who then gave it to her assistant to be handled, okay? And suggest that he do the same, because it's either going to be Pamela's insurance that pays for it or it's going to be his insurance that pays for it. And they said, why don't we just have this settled by mediation and arbitration? And she phoned him up and said this, and he said, yes, that's a good idea because I want more dough next month. Okay, now try that after you sue someone. I guarantee that they will not say, okay, I really want to continue doing work with you and we'll have this lawsuit on the side where we'll hate each other. It just isn't going to happen, okay? You can preserve ongoing relations, and that is a big plus. Not always, of course, but you have an opportunity for that. And the other thing to remember is you don't get into arbitration unless you put a clause in the contract. Okay, next advantage, awards are final and binding. The whole point of arbitration is you get one shot at it. Okay, in court you lose at trial, well, let's appeal. And you lose on appeal, well, let's appeal to the Supreme Court of Canada. It can go on for 12 years. Okay, arbitration, the idea is let's just get it over with quickly. Now, this is also one of the disadvantages that I'll talk about later, because if you were in the right and and the award was against you, then obviously you're going to be upset because there's no avenue for appeal within reason, and I'll talk about that in a minute. But the idea is that the sword of Damocles is not hanging over your head, that this matter is going to 3 years and you're going to get into court, and then 1 year later it's the trial's taken care of, that's 4 years, and then there's an appeal and it's a year getting into appeal, and then it goes on and on and on. So award is final and binding. That's a real plus. Then the next one is it's enforceable as a judgment. Because if you got an award by a private arbitrational firm, what good is it? Okay, if you go to court, then you have a whole series of ways which you can enforce your judgment if the other side does not pay. We'll get into that in topic number 5. Suffice it to say right now that there are all these things you can do with a judgment. Well, if you get an award and the award isn't a judgment, what can you do? Well, you just take the award down to the courthouse, you pay a little fee, court stamps it, and bingo, it's turned into a judgment, and now you can commence proceedings to enforce your judgment. The 10th advantage, and I'm sure there's probably more, there's one that I'll just sort of mention as a possibility, although I haven't investigated it yet. It's enforceable internationally. Okay, I think I mentioned, and if I didn't, I'm saying it now. Back in 1958, the United Nations was passing all these conventions, and they'd pass a lot of conventions that were very controversial, and some countries would sign it and some wouldn't, and then some countries would do enabling legislation after signing it and others wouldn't. But one thing was that they tried to do was always international convention for the international sale of goods, the carriage of goods by sea, the carriage of goods by air, anything with respect to commerce seemed to go ahead. Then they tried to pass the United Nations Convention on the Enforcement of Judgments, so the judgment in one country would be enforceable in the other. So a common law judgment from BC would be enforceable in Mexico, for example, or in France. And countries signed it, and then they went back and they looked at doing enabling legislation, and the reaction by the courts was, hey, we're giving up our sovereignty here. We're giving up our ability to control our judicial system. And so only about 5 countries passed enabling legislation, and not significant countries for the most part. So we had the situation where you have a convention, but it's really not applicable. At the same time, they also passed a convention on the international enforcement of arbitral awards. And all the countries signed it, and then they went back home, and most countries passed enabling legislation. Why? Because it wasn't a big deal. You weren't giving up sovereignty, because they didn't understand that the arbitral award would then be changed into a judgment, which would be the same, right? And it wasn't widely used, so it didn't seem like a big deal. So most countries have signed that, which means a BC judgment can be taken, a BC arbitral award, which you can get very quickly, can then be taken to Mexico and enforced as a judgment, or taken to Germany and enforced as a judgment. So it's a really big advantage. Okay, so those are the advantages. Now we're going to get into the disadvantages, and I'm just going to take a short break again. We've looked at the advantages of arbitration. Now we're going to look at the disadvantages. And I think it's important to remember, as I go through the list, I'm going to point out why these disadvantages are relatively insignificant. The first one is that no body of precedent is being built up. So arbitral awards, because of their confidential nature, cannot be used in subsequent arbitrations. And then the other arbitral awards cannot be used, because that would be suggesting that arbiters are bound by stare decisis, and they're not, because they're not judges. Okay, so there's no body of precedent of arbitral awards being built up, which can be used to assist in subsequent arbitration hearings. That's not terribly significant. Okay, it is a disadvantage to a certain respect, but what that suggests is that now that we have arbitration, nobody ever goes to court on a commercial problem. No, in fact, arbitrations are increasing in number, but there are still thousands and thousands of cases which go to court. Okay, and so there are thousands and thousands of decisions. And those decisions can be used in arbitrations. It is applying the law, and you are entitled to do that even in an arbitration. So you can use all those precedents. So the fact that arbitral awards aren't being built up as precedent, we still have plenty of precedent to clarify the law. Now, the next one, limitation on equitable relief, can be a disadvantage. Judges have inherent jurisdiction. Arbiters don't. They are not judges. When judges were sent out to make decisions pursuant to, I think it was section or Article 18 of the Barons, they were standing in place of the king. The king used to have tremendous scope in doing anything he or she wanted, king or queen, I should say. And so the judges could give legal remedies and equitable remedies. Well, an equitable remedy is like specific performance. And let me explain. You have a contract with someone, and you have a lease to get minerals out of a certain piece of land. And if the other party reneges on that agreement, you could go to arbitration and you could get damages. But you don't want damages. You want that lease on that property, okay? And so what you want is the arbitrator to say, okay, defendant, you have to allow him under the lease to access those minerals. Arbitrators don't have that ability. Judges have the ability to issue specific performance. And so this sounds like a real disadvantage. Because the statute, the arbitration Act is very specific. It says no equitable relief. And that would be a real disadvantage if the wording ended there, but it doesn't. It goes on to say unless authorized to do so. And so what you want to do is you want to make sure that you get a lawyer to draft the arbitration clause, because the lawyer will say, okay, the arbiter has the jurisdiction to not only grant legal remedies but also equitable relief. And then bingo, the problem is solved. And where the problem crops up is the arbitration center has some sample arbitration clauses. And people go on there and they go, okay, I want to put an arbitration. Oh, look, there's one. Oh, I'll just take that. I don't need a lawyer. What do I have to pay money to a lawyer for? This is great. I'll use that. That one does not say that the arbiter is entitled to grant equitable relief. And so, bingo, yeah, you want specific performance, you're not going to get it. You might win the arbitration, but you're only going to get damages. So that is a definite problem unless you have a lawyer do that. All right, now no day in court. I have to be a little careful here because I've got a funny anecdote, or at least I thought it was funny. I brought a Court of Appeal judge out to the university to talk to my BADM 107 students one year. And he talked about the legal system, and then we asked questions about arbitration. And I specifically asked what sort of disadvantages there are to arbitration. One of the ones he said, well, the parties don't feel like they had their day in court. And I almost laughed. Okay, and then I realized, oh, he's serious. And the reason I almost laughed is when somebody goes to court, one party wins, one party loses. The party that wins is happy, the party that loses is not. And I don't think I would ever see a defendant that lost or a plaintiff that lost his claim walk out of court and say, gosh, darn it all, I lost, but hey, I feel so darn good that I had my day in court. And so I thought he was joking, and then I thought, no, he's serious. And then I thought, okay, he's a judge. He has to buy into the court system. He has to feel that the court system is the real system and that arbitration is just something on the side. And so he was serious. I don't think it is. I think when people go to arbitration and they get their award and it can be changed into a judgment, that one party is happy because they had their day in court and the other party is not happy. Okay. It doesn't matter whether you go to court or arbitration, they're just not going to be happy. All right, so the no day in court, I put it in though because he is a BC Court of Appeal judge and I am only a professor at the University of Capilano. Now there's a limited right of appeal, and I'm going to put a copy of the relevant sections of the International Commercial Arbitration Act online, and you can see in there that you can only appeal if one of the parties lacked capacity. Well, that's the same as court, okay? And you can only appeal if the scope of the decision is outside the contractual dispute. So we have a contract for the purchase and sale of goods, and then we have a dispute over something else, and we go to arbitration. Well, the arbitration isn't covered by that clause. And then you can only appeal if there's an error at law, or you can only appeal if the decision is against public policy. And I have a hard time figuring out a public policy that might offend a commercial transaction. I guess maybe it would be with respect to the sale of guns, and there's a public policy in Canada that the regulation of guns is controlled, and so we have a dispute here, and I'm going to make an award that actually offends that public policy. Okay, so there very few of those actually apply. Now, if I lose, and I have had a hearing, I cannot appeal because I didn't like the decision. Okay, but if the arbitrator said, yes, there is a contract, and obviously it is binding, and all the 6 binding elements of a contract are there, but I just don't think it's fair to enforce it here. Well, that would be contrary to the law, okay, because contracts must be enforced. And so that would allow an appeal. But an error on the facts, no chance, okay? And then the last one is the whole public policy issue. To give you an idea of something that was against public policy, this isn't a commercial arbitration, but it'll give you the idea. There was an aircraft, passenger liner that crashed in the ocean just off of Newfoundland, and the Navy and some private boats went out to see if they could rescue survivors. In actual fact, they really went out to pick up the bodies because it's very unlikely you're going to survive the crash, and then if you're in the ocean, the North Atlantic, you're going to die of hypothermia. Anyway, one of the Navy boats got there, a Canadian naval vessel, and the naval personnel were assigned to little boats, and they went out and they were picking these bodies out of the ocean, and one of the naval operators said he isn't in air, sea, and rescue, and yet he was forced to do this, and he suffered trauma because of it, and so he sued the Canadian Armed Forces, and he sued the Canadian government. Well, you cannot have soldiers and naval personnel and pilots suing the Canadian government because, in a war or some military action, they suffered trauma. Okay, if you can't handle that, you don't go into the military. So the courts recognized that yes, he did suffer trauma, and yes, the Navy has Canadian Navy has a method of allowing medical help or psychiatric help in a situation like that, but he doesn't get to sue for damages because it would be against public policy. Okay, that's the idea. One concept. Now we've looked at the advantages and disadvantages. Okay, so there's another concept that I want to deal with because there was a Canadian case called Heller versus Uber Technologies, Inc., and it is incredibly significant in the area of arbitration. What generally happens is if someone launches a lawsuit when there's an arbitration clause, the courts will stay the court case. And I've got another anecdote about that. I was a solicitor for a corporation in British Columbia that was developing patentable technology to scrub carbon particles out of the air from the emissions in the stack of a ship. And it was really good technology, and they got into a dispute with a patent holder who was also part of the corporation. The patent holder lived in Nova Scotia and wanted to sue to get the patent back. And he was like, they're all shareholders, right? And so he launched this lawsuit to get the patent back, which, and the sad thing about this is the lawsuit, got stayed, and it was supposed to go to arbitration, and nothing ever happened. And the patentable technology, which would have been very valuable for not only Canadian businesses but helpful in the environmental sphere, nothing's happened. Okay, and they're waiting for the patent to expire, but by then somebody else will have developed technology that'll supersede that. Anyway, so that's the sad part. But what happened was the shareholder said, I'm suing pursuant to the shareholders agreement, and I'm demanding that the patent be returned to me. And he started the action in Nova Scotia, and I was meeting with the director of the company, and he said this is going to be really expensive, and that we have to decide whether we're going to go to the bother of going all the way back to Nova Scotia and fighting this court case, and it'll be delays 3 to 5 years, and it's just terrible. And I said, well, I did a shareholders agreement for you for the company, and he said, yeah. And I said, well, I put an arbitration clause in there. And so we looked at the arbitration clause, and it said disputes with respect to the shareholders agreement and any matters related to the operation of the company and the patent had to be referred to mediation and arbitration. Actually, I don't even think mediation was in there at that point, because at that point we were talking about just arbitration. I said it had to go to arbitration. And so we notified a lawyer in Nova Scotia who went in, brought an application, and said this matter gets stayed. pending arbitration. Well, the person in Nova Scotia had already spent money to start the lawsuit, and now was going to have to spend money to fly out to British Columbia and do an arbitration, and then fly back, and then come out, and fly back and come out, and it was going to be incredibly expensive for them, and they'd already spent money. Because that court case got stayed, he never proceeded. Okay, and so the matter, and unfortunately, it was never decided, and so the company just said, well, the shareholders said, we're not going to go ahead with this because we're not going to get halfway through and then have the patent yanked back. But the matter was stayed because there was an arbitration clause. Okay, now they only stay it, which means they can bring it back on if the arbitration doesn't take place. Okay. But he was the one that started it, so if he doesn't do the arbitration, he's not going to do the court case either. So, because he didn't have the option, so that's what happens. The arbitration goes ahead, and the court case is stayed. In Heller versus Uber Technologies, Uber Technologies is a company out of, I think, Delaware, in the United States, and they have subsidiaries all over the world. And what happened was, and they have a contract with each of their Uber drivers. And in that contract, there's an arbitration clause. So Heller was an Ontario driver, and he had a dispute with the company, and he started an action against the company under the Employment Standards Act. And Uber brought an application saying the matter has to be stayed pending arbitration, and the court in Ontario, the lower court, granted that. Well, the problem with that was the arbitration clause said that arbitrations shall occur in the Netherlands under the civil code of Netherlands. And of course, the Uber driver, there's no way he could afford to go to the Netherlands, hire counsel over there, pursuant to the civil code, and commence an hire counsel over there and commence an arbitration under the civil law of the Netherlands. And so the matter was appealed to the Ontario Court of Appeal, and the Ontario Court of Appeal said, okay, first of all, that clause is absolutely unethical. Which doesn't mean anything because it's unethical, but it's legal, right? It's unethical because what does the Netherlands have to do with this transaction between a U.S. business and a Canadian business? And they said the only purpose of that was to make it impossible for an Uber driver to actually commence an action against Uber Technologies. And then the judge went one step further, and he said, as a consequence, it's not only unethical, but it is unconscionable. Okay, unconscionable. Write that down. Unconscionable. There's something that you should know. Unconscionability is a factor which can be used to challenge the validity of either a contract or a clause in a contract. So the arbitration clause was held to be void at law because it is unconscionable. So there was still a contract, but arbitration should not take place, and so Mr. Heller was allowed to proceed with his court case. Okay, under the Employment Standards Act in Ontario, which gave him the advantage over Uber Technologies. So that's really a significant case. Now, there was an appeal filed, and I will actually make a note right now, Uber appeal, and I'll check to see if the appeal has gone ahead. So it went from the Supreme Court of Ontario, where the judge said there's an arbitration clause, so the action has to be stayed. It went to the Ontario Court of Appeal, where 3 judges together said this is unconscionable, that clause is void, therefore the action can go ahead, and Uber Technologies has appealed to the Supreme Court of Canada, and I'll see if that has taken place. So, as far as arbitration clauses go, there is a potential for an unethical action. Now, there's nothing unethical about the appointment of arbitrators because that's all been taken care of. So it's just an unethical situation where, well, let's use peak performance pontoons and Good Day Mate in Australia. Peak performance pontoons, because they have the upper hand, could say arbitration in the BC International Arbitration Centre pursuant to BC law. Totally legal, but somewhat unethical because it puts a tremendous burden on Good Day Mate out of Australia to travel all the way up here to commence the arbitration and then travel all the way up here to have the arbitration hearing. So that would be unethical. Okay. And if BC, if Peak Performance Pontoon said arbitration in the Netherlands, then it goes one step further and it becomes unconscionable. But just because it's unethical doesn't mean it's illegal, but there is this potential that arbitration could be used unethically. But it's kind of irrelevant because in a contract, if Peak Performance Pontoon said that BC law shall apply and the matter shall be referred to the BC Supreme Court, then that would be considered to be somewhat unethical too, because it's forcing them to Good Day Mate to travel all the way up here for a court case. So it can be slightly unethical in that regard, but if they go one step further, like Uber Technologies, then it becomes unconscionable and illegal. Okay, so this section ends with a little tick mark on slide number 71 that says have a lawyer draft a mediation arbitration clause for two reasons. Number one, to make sure that there is a clause in the agreement, because you'll see that an arbitration clause must be, let's see if I can grab it quickly. I've got on my screen here. In Section 7 of the International Commercial Arbitration Act, it says an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Okay, so you've done the contract, and then afterwards both parties say, you know what, we should probably go to arbitration if there's a dispute. Well, you've already got the contract signed, so you just do another agreement saying you agree to arbitration. And the other kicker is that subsection 3 of section 7 says the arbitration agreement must be in writing. Okay, so it cannot be an oral agreement. Okay, so you get the lawyer to draft the clause to make sure that it complies with the requirements of the Act. Because if you don't, you're not going to go to arbitration, right? And then the other reason you get the lawyer to do it is to make sure it's properly drafted and there's a possibility of giving equitable relief. Okay, and there's other things too. For example, in the arbitration clause that I use for my clients, I put in the thing about our equitable relief, obviously, but I always put in that if the matter is less than $35,000, they might want to go to a small claims court to resolve the dispute, because that's probably going to be faster. Well, not faster than, but less expensive than going to arbitration. So I say they can go to small claims court if they want, or if they choose, or if the matter is in excess of $35,000, then they go to arbitration rather than the courts. Okay, but I also say, well, mediation and failing mediation, then arbitration. And then I also put in a clause at the end which says that the arbiter may award an injunction. What's the difficulty with that? Well, you're infringing my trademark, okay, and we have an arbitration clause. So I can get into arbitration in 3 or 4 months, but you're still infringing my trademark. Like, what's to stop you from infringing it for 4 months? And so I can actually go to court and get an injunction, which doesn't affect the arbitration clause, get an injunction to have you stop infringing my trademark until we can have the arbitration hearing. Okay, and so I put that in as well. And so you want a lawyer to do it. Number one, to make sure it's in writing and complies with the statute, and number two, to make sure that these other factors are taken into consideration. Okay, so that finishes dispute settlement the 6 methods of settling international disputes, and we saw how one of the problems is when you get an award from arbitration or you get a judgment from a court, that the next step is obviously enforcement. Okay, and the court judgment is obviously enforceable, but what makes the arbitration award enforceable? It's because in that statute, which, oh dear, I've just clicked it off by accident. There we go, got it back. It says recognition and enforcement. It says that the award is binding and application can be made to the Supreme Court of BC for enforcement. And this is pursuant to the Foreign Arbitral Awards Act, which is that United Nations Convention. So what's the Act? The Act is enabling legislation to make the Convention the law of British Columbia. And I've also posted that, and I'm just going to read it here. It says, convention means the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, as set out in the schedule here too, and then Section 2 of the Act says the convention applies in BC, and Section 3 says the Act applies only to the recognition and enforcement of awards respecting differences arising out of the legal relationship between the parties on a commercial matter. Okay, and the court shall be the Supreme Court of BC. And how do you do it? You just go down and have the arbitration award recognized as a judgment. And that brings us into topic number 5, which we will deal with next. Thank you. Now we're moving on to topic 5, the recognition of foreign judgments. We've already looked at the difficulty of having a judgment from a court in one jurisdiction enforced in another. We have a slight advantage with respect to arbitral awards because under the International Convention, those arbitral awards can be turned into judgments in those other jurisdictions. But now we're going to look at actually what you do in order to collect on your judgments. This is called levy execution. Once a judgment has been rendered by a court, or once an arbitration award has been awarded and then turned into a judgment, the judgment creditor, that's the person that's owed money pursuant to a judgment, then has to levy execution against the judgment debtor, a person that owes money based on a judgment. Levy execution, by the time you've done this process, execution, it's like, you really do want to execute somebody because it's almost as frustrating, if not more so, than the actual trial itself. So you go into court and you win a judgment against a defendant and you're walking out of court and you say, okay, when can I expect you to pay that? And the person gives you that sort of, one-fingered wave that I can't do because I don't want to be reported to the dean. It says, when hell freezes over, and then he goes out and he jumps into his Ferrari and he drives off. Vroom. What do you do then? Well, then you have to start this process of levying execution. One thing you can do is you can garnish that person's wages if they're employed somewhere. So, for example, if you sued me under a judgment for, let's say, $5 million, you get $1 million from my insurance fund, and then you have to try to collect the other $4 million. What's the likelihood of getting that? Not great. But I am employed, as well as doing a law practice, at the University of at Capilano University. So what you can do is you can go to the registry and you can fill out a garnishing form and get it stamped, and you can take that form, garnishing order, down and serve it on to the Capilano University faculty services, and they will, when my paycheck goes out at the end of the month, take 1/3 of that paycheck and pay it into court. Okay? Then you can go to court and you can present your judgment and you can get that 1/3 paid to you. Well, if you're owed $4 million from me, believe me, Capilano University doesn't pay me enough that you're going to be able to garnish my wages and get that $4 million. There's that difficulty, and we'll come back and talk about a dry judgment in a minute. But so there's that problem. And then There might also be the problem that I am not employed. Okay, I might be a business person and I might be getting paid under the table, and so there's no record of transaction that you can then go to the court and say, I need a garnishing order. And the other thing is, you might have a garnishing order against my bank account, but if I'm the type of debtor who is slippery, I'm going to have money in different banks at different accounts, so that you render a garnishing order on one bank and there's nothing there. Okay, and you cannot garnish a whole bunch of banks just taking a shotgun blast at somebody, because the courts don't allow you to do that. You have to have some specific knowledge that the debtor banks at a certain bank before they allow you to do that. Okay, so garnishing orders may or may not be of help. Failing that, I drove off in my Ferrari, so you want to attach my Ferrari. Okay, so if you just grabbed my Ferrari, good, but you couldn't do anything with it because you cannot sell it, because the transfer papers are not in your name and nobody's going to buy it off you. So what you have to do in that situation is you have to go to court and you have to ask for an order of seizure and sale. So you grab my Ferrari, and according to the order, and then you give it to an auctioneer, and the auctioneer sells it, and then you get what's owed, and then the balance that's left over comes back to the owner of the vehicle. Okay, well, that works as long as the person has assets in their name. But if I've structured my affairs so that I am judgment proof, then you're going to look in the land registry, and I don't own any land. You're going to look in the personal property security registry. I don't own any personal property. You're going to look in the vehicles registry. I don't own any vehicles. I live in a nice house. I drive a nice car. I sail on a nice sailboat. I go down to a cottage on the weekend. But all those things are in my spouse's name, which makes me judgment proof. Judgment proof. And you're not going to be able to seize any assets. All right, well, the third thing you can do is try to be as big a pain in the neck to me as I am to you. And what you do is you go down to the court registry and you get 12 payment hearing forms, and you fill them out. Put what's the month today? July on one, August on another, September on another, October on the other. And you serve the payment hearing notice on me. I have to turn up in court, and I have to explain to the judge why I haven't paid the judgment. Now, at trial, when a judge renders the judgment, judgment in favor of the plaintiff for $84,000, case dismissed, and away he goes, the judge is finished. Okay, so the fact that the defendant does not pay that amount of money, that judge doesn't care. However, if you go in on a payment hearing and the judge says, all right, Mr. Holden, why haven't you paid any money? And I give him all the excuses. Okay, Mr. Holden, you shall pay $3,000 a month starting this month until the debt is paid. Well, I didn't pay the original judgment. Why am I going to pay that? You haul me back in on the next month on a payment hearing. Now this judge is seized with the matter. You have disobeyed an order of this judge. That judge is not going to be particularly enamored with you. Or in this case, I'm the terrible debtor, aren't I? So he's not going to be very enamored with me. And I'm going to give all sorts of excuses why I didn't pay the $3,000. The judge may let me go one more time, ordering me to pay the $3,000, okay? Sorry for that little hiccup there. What happened was my battery was about to die, and so it clicked off, and I had to go and plug in. So now we're good to go. And I was just saying that if I get dragged in, on those payment hearings, at some point, the judge is going to be so upset with me that he could actually incarcerate me without due process of law. for contempt of court because I have refused to abide by his order or her order. And I would have to spend the night in jail, and then I'd come back the next morning. And believe me, at this point, one night in a jail like that, and I'll be ready to pay. However, some debtors are really slippery, and they can put these off and drag the process out for a long period of time, which can be terribly frustrating. The fourth thing you can do in order to collect on your judgment is register your judgment against land if the debtor owns some property, and this is very effective provided that the person wants to either get a mortgage on their property or sell the property. Otherwise, that order is going to sit there for a long period of time, and it only lasts 10 years, and then it's expunged. I had a situation where I won a trial for a young man, and he paid me as we were going along, which is fine and dandy, but then there was about $980 left over, and I rendered my bill, and I said, okay, how soon can you pay that? And he said, I'm not going to pay you. I said, sorry, what? He said, I'm not going to pay you. And I said, well, why? I won the trial for you. And he said, yeah. He said, but you're a rich lawyer, and I'm not going to pay you. And I said, well, if you don't, I'll sue you. And he said, yeah, go ahead and sue me. I don't care. And so I sued him, and it was small claims court, and I served him with a copy of the notice of claim. And he called me up and he said, he was laughing, and he said, go ahead. I don't care. I'm not going to do anything about this. So I went down and I got a default judgment against him because he did not file a defense. And I served the default judgment on him, and he called me up and laughing, and he says, so what? Big deal. And I told him that I would start garnishing and, seizing assets and things. And he said, I don't have any assets that you can get your hands on, call me on a payment hearing. Every time you do that, it's going to be, at least $300 a year time, and so it's you'd be smarter to go out and bill somebody. And he was being paid under the table, and so I knew there was no way I was going to get money that way. I did a search, and I found out he owned land way out in the valley somewhere, and so I registered the judgment against the land. He called me up laughing, and he said, leave your judgment there for 10 years and then it's going to be expunged. I don't plan to do anything with that property. Ha, 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 ha. Well, if I haven't, I should mention to you that I've had a very fortunate life. And I'm fortunate he wasn't. He got on his motorcycle, ran into a telephone pole and killed himself. So I had a call from the executor of the estate, a lawyer, and he said, what do you plan to do with your judgment, Mr. Holden? And I went, I plan to have it paid. And he said, okay, well, I tell you what, you release your judgment and I'll tell the receiver for the estate that he should pay you. Well, no, sorry. I said, no, he didn't pay, and I'm not certain about this other person whether they'll pay or not. But I said, because you're the lawyer for the estate, I tell you what, you give me your legal undertaking that you will, when that property is sold for the estate, send me the money and I'll release the judgment. Or I'll give you a copy of the release of judgment. You can hold it, and as soon as you pay me, you can file that. And he got really mad at me. And the only thing I can figure out is that I caught him. Okay, he planned to get me to release the judgment, and then he would say to the receiver of the estate or the heir of the estate or whatever, you never pay him. Okay? Anyway, by putting him on a legal undertaking to hold the judgment and not file it, or release of the judgment rather, and not file it, protected me because there's no way that he could actually file that in court to sell the property until such time as he was sure that he had a purchase and sale agreement and provided his legal undertaking to the other side that if they paid him, he would file the release of judgment. So I was protected, and I did get my money, but only because I was very fortunate in the circumstances. So levying execution can be extremely time-consuming and frustrating, almost as bad, if not worse, than the court case itself. Pardon me, my allergies drive me nuts. Okay, Levying execution internationally is even more of a difficulty because it may be that the foreign debtor has few, if no, or if any assets in this jurisdiction. So I get a judgment against somebody in BC, but he is a foreigner. Then, unless he has assets here, I'm not going to be able to do those sorts of execution proceedings. So then I have to go to that other jurisdiction and try to enforce my judgment there. If I have a judgment of a court, I actually have to go down there and apply to a court down there and get that court to recognize my judgment. And this is extremely difficult to do because it's like fighting a second court battle in another jurisdiction. So it's better if I have an arbitral award, because then I can turn it into a judgment down there, but I'm still left with the problem of having to execute it down there. If it is a monetary judgment, so it's a judgment against them for cash, then there is this statute we have, the Court Order Enforcement Act, which allows for the enforcement of monetary judgments. And it's on slide 76. And it says, if a judgment has been given in a court in a reciprocating state, the judgment creditor may apply to have the judgment registered in the Supreme Court of BC. Well, what's a reciprocating state? It's this Court Order Enforcement Act is pursuant to a convention, and countries agree that they will honor each other's judgments. Some have, few haven't. A reciprocating state is a country or province that agrees to enforce our judgments, provided we do agree to enforce theirs. This is called comity, right? We talked about that earlier. On slide 77, we have a list of the reciprocating states. And at first glance, you go, oh, there's lots, right? But no. The first bunch are all the provinces of Canada, with the exception of Quebec. So Ontario will enforce ours, Alberta will enforce ours, and vice versa, etc. Okay, then we go to other countries. Well, Australia. Then they list all the states of Australia. The state of Victoria, the Australian Capital Territory, that's like Washington, D.C., the Australian Antarctic Territory. Oh, well, I've got lots of contractual obligations with somebody in the Australian Antarctic area. Not likely. The Coral Sea Islands Territory. Hey, there's a biggie. Herald and McDonald Islands. So you can see that, Australia, it's good. We've got that relationship with Australia. And then we get into the United States. Well, there's 50 states in the United States, and there are 6 that are reciprocating states. Okay. Europe, thank goodness. Now we're getting into some real areas, right? Well, there's the Federal Republic of Germany, including Land Berlin. This hasn't been changed since before Germany was united. We used to have East Germany and West Germany after World War II, and they are now united under Germany, and they're a reciprocating state. One country? Well, no, there's two. There's Austria, and then there's the United Kingdom, and that's it. So the Reciprocal Enforcement of Judgment Act really isn't all that effective as a means of doing that. However, we do have a series of Supreme Court of Canada cases, okay? So we don't have legislation which allows the reciprocal enforcement of judgments, but we do have case law. And the first one is on slide 78, and it is the Morgard Investments versus de Savoy case. And I'm just going to look at the screen. It's a leading case for the Supreme Court of Canada on the enforcement of extra-provincial awards. Okay. So we've got the Reciprocal Enforcement of Judgments Act that allows monetary judgments to be enforced across borders in Canada and a few other countries. Now we have the Supreme Court of Canada decision that says, okay, non-monetary awards can be enforceable across borders. not completely, though. It goes on to say the court held that the standard for enforcing a default judgment from a different province is not the same as if it were from another country. Rather, there must be a real and substantial connection between the petitioner and the country or territory exercising the jurisdiction. So they said provinces can do it, but we cannot do it with other countries unless there is this real and substantial connection. Back to taking jurisdiction. Remember that? Okay, and then there was a very, very important case, Pro Swing versus Alta Gulf. In 2006, the Supreme Court of Canada decided that foreign non-monetary judgments may be enforced in Canada, where there has been where they have been rendered by a court of competent jurisdiction. Number one, so it's a foreign court that we feel confident in. So United Kingdom, yeah. Germany, yeah. France, yeah. United States, yeah. Mexico, yeah. The preeminent court of Bajinajistan, maybe not. What about the court of the Duchy of Grand Fenwick? Oh, maybe not. What about the court of Lower Slobovia? Those are made-up countries, okay, so don't go looking for them on the map. But what I'm saying is there are certain judgments from certain foreign courts that we would not have confidence in. We would not have confidence in a court from Russia because there's too much corruption, right? Okay. So it has to be a court of competent jurisdiction. The order has to have finality and clarity. And the nature of the judgment is such that comity requires it. So in other words, you've never enforced ours. Well, what makes you think we'll enforce yours here? Okay, so you enforce ours, we'll enforce yours. So there's three things. And then the fourth thing is it cannot be penal in nature. So it cannot be a criminal matter or a quasi-criminal matter where there is punishment, okay, because we do not punish using foreign laws. So there are four things, and somehow that's got to work into an exam question because it's so important. They actually decided in the Pro Swing case not to enforce a judgment, and I think it was from Ohio or Iowa, one of those states down there, because it wasn't clear enough, it wasn't final enough. Okay. But they said in there, in obiter dicta, remember that, obiter dicta, the court is pontificating. They said as long as these four factors are present, then they will enforce a foreign judgment. Big step forward. Since then, they've actually done that in that case that I mentioned about Brazil mining leases. Okay, so we've got that situation. And I wanted to mention that it shows the 9 judges sitting there, those funny red robes that we saw earlier, the Supreme Court of Canada robes. When I was talking about judicial activism, this is judicial activism in its utmost, all right? And it was McLaughlin, Chief Justice McLaughlin, who listed those 4 factors. And those 4 factors have become the rule to be applied in subsequent cases. Okay, so we do have a convention on the recognition and enforcement of foreign judgments. As I said, it was passed. I think I said 1958. It was 1971, but as of 2010, okay, and I don't think it's changed since then. There were only 5 signatories. Albania, does it even exist now? No, it doesn't. Well, strike that one off the list. Cyprus. Now there's a hotbed of international commercial activity. The Netherlands, significant. Portugal, significant. Kuwait, significant. But those are the only, 4 now, really, because Albania doesn't exist anymore. So we have a lot better luck with arbitral awards. Okay, risk management practice. The Convention on the Recognition of Enforcement of Foreign Arbitral Awards is a big advantage because most countries of the world have ratified that particular convention. Just to close off, we did talk about at one point right at the beginning of the chapter on enforcing or methods of settling international disputes, this immunity. Okay, so they look at forum, they look at jurisdiction, they look at law, and then the last thing they look at is to say, is there some reason why the person being sued has immunity? And the only immunity is what they call sovereign immunity, the doctrine that the municipal court must decline to hear suits against a foreign state or heads of state. And then there's absolute foreign immunity, and then there's restrictive foreign immunity. I'll come back to that in a minute. But really what is meant by this is, another anecdote. Years ago when President Clinton was in office, Somalia was in terrible shape. I'm not sure it's in much better shape today, but it was in terrible shape back then. They had roving bands of bandits, and like small armies, and they were going around the country, and they'd race into a town or a village, and they would murder and rape and steal and everything. And the Somalian police and armed forces seemed to be incapable of stopping it. So they pleaded for assistance, and the United States agreed to send in the U.S. Marines for the purposes of, one, stopping this rampaging warfare, and number two, to train the Somalian army and police so that they could effectively stop this from happening. Well, the United States Marines were in there for the longest time, and whenever there was a problem, they would go out with the local Somalian army, and they would engage the bandits, and it was always the United States Marines engaging the bandits, and the Somalian army standing back saying, okay, we're just watching how you do this. So it was always American casualties, and this went on and on and on, and the United States populace began to get extremely upset at the number of body bags that were coming back from Somalia for seemingly no reason whatsoever. Finally, Clinton had had enough, and he said, okay, that's it, and at a certain time, we're leaving. Okay, so we've prepared you to take care of it yourself. We are going to leave. You have to take care of it. So he withdrew the troops. The Somalian police and armed forces didn't do anything about it, and suddenly you had these raging bands of bandits going around raping and killing again. There was a Somalian landed immigrant in Vancouver whose relatives and friends were in Somalia, and he was so upset about the killing that was going on that he started a lawsuit in the BC Supreme Court and was suing President Clinton for causing wrongful death. Okay, and I'm just going to have to stop here for a second again because my disk is almost full, so I have to do a little bit of rearranging or this video is not going to finish. All right, as I was saying, he sued President Clinton for causing wrongful death. The reason he was suing was he went to numerous lawyers who knew about sovereign immunity and therefore said no, they wouldn't help him. He didn't understand this, so he started the lawsuit himself. I was down at the courthouse library and I heard some lawyers talking about it, and I was really quite upset about it because they were laughing and joking about his poor English and his spelling mistakes and the mistakes he made filling out the forms to commence the action. Everyone has a right to do it, whether it's applicable or appropriate is another matter, but I was quite upset about it. But anyway, he filed the lawsuit and it was set down for trial. And when he turned up at trial, he walked in and the judge said, sovereign immunity, rap of the gavel. Actually, we don't use gavels, but anyway, sovereign immunity, case dismissed. And he was so upset because he didn't understand. Sovereign immunity stands for the proposition that the head of a government or other people in the government of a foreign state cannot be sued. They have immunity from prosecution. Now, it breaks down into absolute immunity and restrictive immunity. President Clinton was doing what he was supposed to do as a president and therefore could not be sued for that. If President Clinton had gone over and shot somebody, then this it would be restrictive sovereignty, meaning the sovereignty is restricted only to his legitimate actions as a government representative, and what he did was outside the bounds of that, and so he could be sued. But the case was dismissed because of sovereign immunity. Now, there are functionaries. Now, functionaries is a term which relates to people in positions of authority in a foreign government, and they are immune from prosecution. Two people licensed by the state of Florida came up to Canada and kidnapped a person that was charged with an offense down there and took him back to Florida. And there was an outrage in Canada that a Canadian could actually be kidnapped and taken across the border. There was very little we could do about it, and we certainly couldn't go after the functionaries, okay, because they were immune from prosecution for doing this. Not so two fellows from California that went down to Mexico and grabbed somebody and brought them back to California to stand trial for a crime. The person that they brought back was a Mexican citizen, and as they were coming back to the United States, they got stopped at the border and caught. Okay, and then they said, "Oh, sovereign immunity, we're acting as bounty hunters to execute this warrant." And the government said, "No, you don't work for the government. You're bounty hunters. You're just, you go out and grab somebody and come back and you get a reward, right?" So they weren't actual functionaries, and so they wound up being in jail in Mexico. So that's the concept of a functionary. There is an article in the material regarding functionaries, and I'm just going to make a note. And I'll put it online. The reason I'm making notes and putting things online is the fact that I used to have a package of material which I'd get printed and sold, but because of COVID-19 and the difficulty of arranging for that, I'm just going to post the most important articles online. Okay, then there's also the active state doctrine, which means that as much as we might be upset with what President Trump is doing, ripping apart families on the southern border, people looking for asylum from Latin America, families that come across, they're ripping the parents away from the kids and sending the parents back. We might really, really be upset about that. I know I am, but there's nothing we can do about it. There's no action that we can take against the U.S. government or against President Trump because of the active state doctrine, which basically says that he's entitled to do anything within his border that is legitimate as far as they're concerned. I mean, Americans might rise up and do something about it, but we can't. Okay, so that's the active state doctrine, the concept that a government within the boundaries of its own jurisdiction is not subject to judicial scrutiny in a foreign municipal court. Now, the kind of interesting thing about this is we talked about the International Court of Justice, which is the takes care of non-criminal matters. The United Nations also established the International Criminal Court of Justice, and that does allow for the prosecution of foreigners for something they do within their borders, supposedly. It's very ineffective. One case is now in its 12th year, and it's still not resolved. When it was put into effect, the United States refused to sign it because it would curtail their ability to grab terrorists around the world and do with them as they pleased. And also Russia was a signatory, but then Putin said, "Oh, I'm going to back out of that because I want to invade the Ukraine, and gosh, you'll stop me from doing that by taking me to the International Court of Justice." So it's a pretty ineffective forum, although it's there and it's struggling and it's trying. Okay. All right. So that concludes topic 5. And I'll get this uploaded if my computer has enough disk space to do so. I'll get it up somehow. Thank you very much.